Over the last several years, there has been an increasing number of states and local municipalities enacting legislation requiring employers to disclose compensation or compensation ranges in various situations, including job postings and upon promotion, transfer, or request by an applicant or employee. For employers, these laws create a patchwork of additional requirements with which they must comply, and employers in Vermont, Massachusetts, Cleveland, and Delaware should be aware of recent and upcoming changes in this area. On July 1st, 2025, Vermont's pay transparency law took effect. The law requires a covered employer, meaning any public or private employer with 5 or more employees where at least one employee works in Vermont, to include the compensation or range of compensation in all written advertisements for Vermont job openings, including remote jobs to be predominantly performed in Vermont. Under the law, a covered employer would include recruiters and third-party agencies acting on an employer's behalf. Moreover, a range of compensation is defined as the minimum and maximum annual salary or hourly wage that the employer expects, in good faith, to pay for the advertised job at the time the employer creates the advertisement. The law applies to internal and external written job advertisements, including positions into which current employees can be transferred or promoted. It does not include oral advertisements or general help wanted notices. Commission-based jobs are required to disclose that fact, but are not required to disclose compensation or a compensation range. However, tip-based jobs must disclose a range of non-tip wages that the employer expects to pay the individual. Although the law does not give applicants or employees a private cause of action, the Vermont Attorney General is responsible for enforcement and can add violations if an employer retaliates for asserting rights under this law. Massachusetts has also enacted a pay transparency law, and it goes into effect on October 29th. Although largely similar to Vermont's law, Massachusetts law applies to public and private employers and their agents with 25 or more employees in Massachusetts. In addition to job postings, transfers, and promotions, Massachusetts also requires employers to disclose pay ranges when an employee is offered a new position internally with different job responsibilities, or to a current employee for their current role upon request. Pay ranges must be disclosed in job postings where the primary place of work is Massachusetts, including remote jobs and jobs that can be performed remotely to a Massachusetts worksite. Additionally, Massachusetts law makes it unlawful for a covered employer to discharge or otherwise retaliate or discriminate against any employee or applicant for exercising their rights under the law. And the law gives employees and applicants a private cause of action to seek relief in such circumstances. Otherwise, the Massachusetts Attorney General has the sole ability to enforce the act, and employers found to be in violation may receive a warning for a first offense, but subsequent offenses can result in fines ranging from $500 to $25,000. In Ohio, Cleveland has now joined Cincinnati and Toledo in enacting a pay transparency law that goes into effect on October 27th. Cleveland's law requires employers to include a salary range or scale in an advertisement offering an opportunity for employment, but it is not required for internal transfers or promotions. Furthermore, the law only covers private employers who employ at least 15 employees within Cleveland, and this extends to job placement, referral, and other employment agencies, and agents acting on behalf of the employer. Unlike other laws, Cleveland's law does not define a salary range or scale, but until guidance is provided, employers should disclose a good faith range that they expect to pay the individual. When doing so, employers should note that Cleveland has broadly defined salary, which includes, among other things, commissions and benefits. Unlike Cincinnati and Toledo, however, Cleveland's law does not provide a private cause of action to employees or applicants, and Cleveland's Fair Employment Wage Board is solely tasked with enforcement. Lastly, employers with employees in Delaware should prepare for its recently enacted pay transparency law, which goes into effect on September 26, 2027. The law applies to both public and private employers with 26 or more employees anywhere, requires salary or wage ranges and a general description of benefits in all internal and external job postings, extends to jobs located in Delaware and non-international remote positions offered by an employer who is based in Delaware, and requires employers to disclose whether jobs are commission or tip-based. Delaware's law also requires a range to be set in good faith by reference to, for example, the actual range of others currently holding equivalent positions or the budgeted amount for the position. Additionally, the law imposes on employers an obligation to retain records of job descriptions and salary or wage rate history for the duration of employment and for 3 years thereafter, and to provide such information to the Delaware Department of Labor upon request. Enforcement responsibility is assigned solely to the Delaware Department of Labor, with written warnings for first offenses and civil penalties ranging from $2,000 to $10,000 for subsequent violations. In addition to these developments, employers should remember that 17 other states and local municipalities have enacted similar laws. We will link our prior Labor Speaks on this topic. To ensure compliance and avoid potential penalties and legal action, we strongly recommend developing a procedure and plan around disclosing compensation ranges in job postings. The team here at Aiken is here to help, so please feel free to reach out to a member of our team with any questions you may have.